May I please, Your Lordship? Lordship, in this matter, I am aggrieved by the wrong fixation of pay. So that is my grievance, Your Lordship. Yes. Lordship, I was initially appointed on 8th of October 2002. I was appointed as senior research assistant in the institute named Institute of Advanced Study in Science and Technology. At that point of time, it was run by the state government. Subsequently, on 9th March 2009, with effect from 9th March 2009, it was taken over by the central government as an autonomous institute, and my post was redesignated as Technical Officer B.
You were appointed as
I was appointed as Senior Research Assistant,
on 8th of October 2002.
2002,
Appointed as senior
Senior Research Assistant.
in
Institute of Advanced Study in Science and Technology, IASST in short. IASST. It's a research institute in Guwahati.
Okay.
Subsequently, Your Lordship, at that point of time, I was carrying the pay of 4390. For short, I'll say it is 4390, and it is as per the 5th Assam Pay Commission. I was carrying the pay as per the 5th Assam Pay Commission. And the initial pay of that pay band was 4390, and the ceiling pay was 11425. And subsequently, with effect from 9th March 2009, the institute was taken over by central government.
2009.
2009, 9th March 2009. With effect from 9th March 2009. And I was redesignated as Technical Officer B. My post was redesignated as Technical Officer B.
Technical Officer B.
Technical Officer B.
Yeah.
And at that point of time, Your Lordship, Technical Officer B under any central government institute was drawing a pay as per the 6th Central Pay Commission. That is 15,600 was the initial pay. Ceiling pay was 39,100 and grade pay of 5,400. So that was a Technical Officer B in other institutions. Now, Your Lordship, what has happened here? Subsequently, in 2010, on 4th of February 2010, a notification was issued by the state government whereby the 6th Assam Pay Commission was brought into force with effect from 1st of January 2006, retrospectively. So my contention is that when the institute was taken over by the central government, my pay was as per the 6th Assam Pay Commission, not as per the 5th Assam Pay Commission. So when my pay is fixed as per the 6th Central Pay Commission, it ought to be equivalent to the 6th Assam Pay Commission. So that is my case. Now, what the respondent number 6, that is the institute, has done, they say that when I was taken over by the central government, I was carrying the 5th Assam Pay Commission. And at that point of time, 6th Central Pay was already in force. So what they needed to do, they needed to convert my 5th Assam Pay Commission to 5th Central Pay Commission, which was again converted to 6th Central Pay. Sorry, Your Lordship. So, Lordship, what they have done, they say that they have applied equity, and they say the 4390 5th Assam pay scale is equivalent to 7,500 in the 5th Central Pay Scale. Now, here is the main problem, this equity problem. Now, after that, the 7500 in the 5th Central Pay goes to become 9300 in the 6th Central Pay. There is no grievance on that part. Now, Lordship, if equity is to be followed, then the 6th Central Pay scale of 9300 ought to be equivalent to the 6th Assam Pay scale of 12,000 with 5400. So that is not the case here. Because as per the report of the Assam Pay Commission Committee, it says that the scale of 12,000, Assam pay scale of 12,000 with grade pay of 5400 is actually equivalent to 15,600 with grade pay of 5400 in the 6th central pay. So the respondent number 6 has committed an error in fixing my pay. It is my simple case, Your Lordship. And Your Lordship, one more contention that has been taken by the respondent is that when my pay was fixed by the institute, at that point of time, they were not aware about the Assam 6th pay because it was notified in 2010. Your Lordship may kindly take page number 49 of my appeal. Page number 49, it is actually a part of the writ petition, annexure of the writ petition itself. Page 49. This is my fixation order as per the Assam Pay Commission, 6th Assam Pay Commission.
Yes.
Your Lordship may kindly note the date by the signature of the head office. The date says 12 February 2011. So
Yes.
my pay as per the Assam Pay Commission was done, fixation was done on 11th of February 2011. Your Lordship may now kindly take page number 52. This is the fixation order as per the central payrolls. And here my pay was fixed at 9300. Lordship may kindly consider the date on the next page, page number 53, bottom left. The date is 30 June 2011. That means fixation as per the central pay was done after the fixation as per the Assam pay. So the institute was aware that the Assam Pay Commission was already into force. And this thing is also reflected in my service book. Lordship may kindly take my service book at page number 158. This is the
So
type.
you are seeking pay parity with the technical officer B in the central institution.
That's the second aspect. First aspect, Your Lordship, is about pay protection. My pay, grade pay was 5400. It cannot be arbitrarily reduced to 4800. My main contention is about pay protection. If pay protection is granted, pay parity will follow as a consequential relief, Your Lordship.
How the learned single judge has dealt with this?
Lordship may kindly take the operative part, page number 93. The judgment starts at page number 85. And the operative part of the judgment is at
No,
para number 12.
First of all, you show us
Lordship.
that these arguments which you are raising, first of all, pay protection
Yes, Your Lordship.
and then the consequential relief
Pay
where
parity.
you have raised before the learned single judge.
Yes, these two aspects.
Where you have raised these contentions before the learned single judge and where is the learned single judge noted these contentions?
Lordship, paragraph number 9 of the judgment,
Yeah, read.
two issues were framed by the learned single judge. Page number 92.
Paragraph?
Paragraph number 9, page number 92.
Yes, read.
Lordship, I have perused the materials on record and have heard the learned counsels appearing on behalf of the parties. From the contentions so made by the learned counsels for the parties as well as from the pleadings on record, two issues arises for consideration. Number one, whether the petitioner is entitled to the revised pay scale in terms with rules 2010. And second is whether the petitioner is entitled to pay parity on the principle of equal pay for equal work.
That's the conclusion.
Lordship, to decide the first issue, it would be relevant to take note of the contentions made by the learned counsels for the parties. Mr. F. Khan, the learned counsel appearing on behalf of the petitioner, has submitted that the petitioner was enjoying the pay scale of rupees 4390.90 by virtue of the revision of pay and in view of the coming into effect of 2010 rules, the petitioner's pay scale was increased to the pay band of 12,000 to 40,000 with grade pay of 5,400. This was brought into effect with effect from 1/1/2006. And as such, after the petitioner have become a central government employee, his pay band could not have been reduced to 9300 to 34800 with grade pay of 4800 in as much as the same would violate the principle of pay protection. So this was my contention, Your Lordship.
Now come,
Lordship.
read.
On the other hand, Mr. D. Gogoi, the learned counsel appearing on behalf of the respondent number 6, had submitted that the petitioner was absorbed as a central government employee with effect from 9/3/2009. The central government had accepted the sixth pay recommendation with effect from 1/1/2009. In terms with the central rules of 2008, there was not an exact match to pay the pay band of 43909011,425, which was enjoyed by the petitioner prior to conversion. However, the corresponding pre-revised pay scale for the central government employee was rupees 7500 to 250 and ceiling pay was 12,000. Accordingly, in terms with the revisions so carried out as per the central rules of 2008, the revised pay band for rupees 7,500 to 12,000 was rupees 9,300 to 34,800 with grade pay of rupees 4,800, and accordingly the petitioner's pay has been fixed in terms of rules of 2008. He further submitted that the question of pay fixation is evaluated and determined by an expert body, and interference with the same would have a cascading effect, creating all kinds of problems for the government and the authorities. In the backdrop of the above contentions, the learned counsel for the respondent number 6 submitted that this court, in exercise of the powers under Article 226 of the Constitution of India, has kept in mind that granting of pay scale is a purely executive function and the court ought not to interfere with the same. In the backdrop of the above, it would be seen that the petitioner was enjoying a pay band of rupees 4300 to 90 to 11425 at the time of absorption as a central government employee. At that relevant point of time, the central government employees were already enjoying the revised pay scale in terms with the sixth pay recommendation. A perusal of the central rules of 2008 shows that there is no corresponding pay band of rupees 4390, 90, 11425, and the pay band which can be applied was rupees 7500 to 250 to 12,000. Accordingly, the authorities concerned have applied the said pre-revised band of rupees 7500 to 250 to 12,000 and fixed the revised pay of the petitioner at rupees 9300 to 34800 along with grade pay of rupees 4800 with effect from March 2009. Subsequent thereto, the rules of 2010 of the state of Assam had revised the pay band of rupees 4300 90 11425 in the pay band of rupees 12,000 to 14,000, so 30,000 with grade pay of 5400. This came into effect from 1/6/2006, but the rules of 2010 was brought by a way of notification on 4/2/2010. Under such circumstances, the petitioner would definitely be entitled for the pay band of 12,000 to 40,000 with grade pay of rupees 5400 for the period from 1/1/2006 to 9/3/2009. However, for the period after that, as the petitioner comes within the ambit of the rules of 2008 and his corresponding pre-revised pay was rupees 7500 to 250 to 12,000, which was in the similar band with 43009011,425, the petitioner's entitlement to the revised pay band can only be rupees 9300 to 34800 with grade pay of rupees 4800. Any interference with the same as sought for by the petitioner would have the effect of changing the entire pay bands as notified by the central rules of 2008, which was based upon the recommendation by an expert body, that is the pay commission. Under such circumstances, this court is of the opinion that the respondent authorities, more particularly the respondent number 6, have rightly fixed the pay band of the petitioner at rupees 9300 to 34800 with grade pay of rupees 4800. Lordship.
Next.
Lordship, next is for equal pay for equal work. I'll read your Lordship.
So you are not insisting this or insisting this also?
I'm insisting on the first, this part only, till the paragraph number
Not this.
12.
What about second equal pay, equal work?
Equal pay, it will come as a consequential, your Lordship. It will come. I'm also pressing on that, but
So
it will come.
Let's
Yes, your Lordship.
go to the finding of the land single on that aspect.
Lordship. The next question which arises as to whether the petitioner is entitled to claim equal pay for equal work, taking into consideration that the petitioner discharges similar function and work as that of similarly situated employees of Indian Institute of Technology, Guwahati, and Indian Institute of Technology, Kharagpur, etc., who enjoys the pay band 3 and given pay scale of rupees 15600 to 39100, along with the grade pay of rupees 5400. The learned counsel for the petitioner had submitted that the petitioner is holding the post of technical officer B in the physical science division of the ISST. The petitioner had submitted his PhD thesis on March 2009 and had obtained a PhD degree from the Guwahati University Experimental Dusty Plasma Physics in the year 2010. He submits that for the technical officer grade 2 in the Indian Institute of Technology, similar qualifications and experience are required for appointment. He submits that the petitioner is rendering similar services as has been done by his counterparts who are the employees of the Indian Institute of Technology, Guwahati, and other Indian Institute of Technologies. And counterparts are enjoying the pay band 3 and given pay scale of rupees 15600 to 39100, along with grade pay of rupees 5400. On the other hand, Mr. D. Gogoi, the learned counsel appearing on behalf of the respondent number 6, submits that the petitioner was recruited as a central government employee on the basis of his post being converted from the government of Assam to the central government. And as such, the petitioner's recruitment cannot be equated with direct or regular employment to the various institutions referred to by the petitioner. He further submitted that the petitioner's services are not transferable, whereas the technical officers grade 2 who are appointed to the Indian Institute of Technology are transferred from one place to another, and as such, the distinction which have been drawn of not giving equal pay for equal work is based upon an intelligible differentia for which the same need not be interfered with by this court. The answer to the said contentions can be found from the judgment of the Supreme Court in the case of State of Bihar and others versus Bihar Secondary Teachers Struggle Committee, Munger, and others, reported in 2019-18 SCC 301, wherein the Supreme Court was dealing with the nature and duties performed by the Niyojit teachers with government teachers. In paragraph number 87 of the said judgment, the Supreme Court had categorically observed that the Niyojit teachers as well as government teachers perform the same nature of duties, and both the set of teachers taught in the same school as well as the same syllabus. The Supreme Court in the said judgment referred to the earlier case laws in copious detail. In doing so, in paragraph number 96.9, the Supreme Court observed that before entertaining and accepting the claim based on the principle of equal pay for equal work, the court must consider the factors like the source and the mode of recruitment or appointment. This court finds it relevant at this stage to refer to paragraph numbers 100, 101, 102 of the said judgment, which are reproduced herein below. We may, at this stage, deal with the submission advanced on behalf of the state.
Leave this part.
Lordship.
Leave this quotation part.
I'll read this part, Lordship.
Quotation part, leave it.
Leave, Lordship. Paragraph number 15, page 104. From the above quoted paragraph of the said judgment, it would transpire that the mode of recruitment can be taken as a factor for the purpose of accepting or rejecting the claim based on the principle of equal pay for equal work. It would also be relevant herein to take note of that the petitioner's service is not transferable, whereas the service of the technical officers grade 2 are transferable, and as such, they fall in a different class from that of the petitioner. Further, the mode of recruitment as a central government employee of the petitioner with that of other persons who are employed in the IITs is also distinct and different in as much as the petitioner's services were converted from a government of Assam employee to a central government employee, whereas persons in the IITs are recruited by either direct recruitment or promotion. It cannot also be lost sight of that the pay band number 3 as sought for by the petitioner is given to the assistant professors, and services of technical grade B cannot be equated with assistant professors. Considering the above, this court is therefore of the opinion that the question of giving pay parity to the petitioner with similarly situated technical officers grade 2 of the Indian Institute of Technology, Guwahati, or other institutes of technology cannot be applied to the case of the petitioner. In view of the above observations, this court therefore do not find any merit in the writ petition for which the instant writ petition stands dismissed. Lordship. But your Lordship,
How this finding is incorrect?
Lordship, my main grievance is at paragraph number 12, your Lordship, of the judgment. Herein, the learned single just says that till 9 March 2009, I am eligible to get the pay of 12,000 with grade pay of 5400.
Yes.
But suddenly after that, my pay is reduced to a grade pay of 4800. When I come,
You became a central government employee.
I became a central government employee. Now, your Lordship, when my pay fixation is done as per the central government, it ought to be equivalent to 12,000 with 5400. But
How?
because as on 9th March 2009, my pay in the state government pay was 12,000 with grade pay of 5400. Now I'm converted to central government. So when I go to the central government, my pay should be equivalent to the one I was carrying in the state government.
No. This 12,000,
Lordship.
how this 12,000, how it was happened, or 12,000? With
Because-
this coming into force of rules of 2010.
2010, it came in,
Prior to that, you were employed as a central government employee.
Lordship, it came into force from 1st January 2000.
That's why only the learned single judge rightly said that up to that period, till
Lordship.
you were absorbed in the central government, you are entitled to get that pay.
Yes.
But not after that, sir. Because you became an employee of the central government.
Yes, I
That was
became,
prior to coming into force of 2010 rules.
yes, I was absorbed as a central government employee with effect from 9th March 2009.
Fine. And these rules came in force, this 2000 rule came into force in 2010.
It was notified in 2010, came into force from 2006 retrospectively.
That came into force retrospectively, you can't say. That is, benefits would be given from the retrospective date. But the
Gotcha.
rules came into force only in 2010.
So if I don't press on that, now when I was say, if I consider that my pay was the 5th Assam Pay Commission, I was at 4390, 5th Assam Pay Commission. And when I was converted to central government, in the central government, 6th central pay was already prevalent. So my pay was needed to be converted from 5th Assam pay to 6th central pay. So how that was done? So 5th Assam pay was converted to 5th central pay, applying equity. They say that 4390 is equivalent to 7500, but there's no documentary proof how this happened. What actually has happened here, Your Lordships?
Yes.
My lord, my pay was fixed at 9300 with grade pay of 4800. Now, what was the basis of this fixation? How was this fixation done? The contention is that the 5th Assam pay was converted to 5th central pay by applying equity. Then from 5th central pay to 6th central pay, that is as per the rules. That is fine. But now the thing is how you have decided that 4390 is equivalent to 7500. They have deployed the principle of back calculation here. Lordship may kindly take page number 112 for a moment, Your Lordship, kindly. Page number 112, this is a part of the affidavit in opposition filed by the respondent number 6 in this writ appeal. I will come from page number 111, fourth line from bottom, Your Lordship. Page number 111, fourth line from bottom, in the peculiar situation. Lordship has got it, page number 111. It's a part of the affidavit in opposition.
Yes.
In the peculiar situation. Fourth line from bottom.
Yes.
Yes, may I read it, Your Lordship? In the peculiar situation, the ISST had adopted an equitable exercise to fix the salary of the converted employees in the new form of ISST. And in
From where they are doing?
Lordship, page number 111, fourth line from bottom.
Okay.
In the peculiar situation, the ISST has adopted an equitable exercise to fix the salary of the converted employees in the new form of ISST. And in accordance with the aforesaid exercise, the pay scale of the employees of ISST is fixed at such pay band in the revised scale, the pre-revised of which are equivalent to the pre-revised scale of erstwhile ISST under the government of Assam. Lordship, I'll repeat this line once again. The pay scale of the employees of ISST is fixed at such pay band in the revised scale. That is a sixth scale. The revised scale, the pre-revised of which are equivalent to the pre-revised scale of erstwhile ISST under the government of Assam. Accordingly, the petitioner's pay scale was fixed in pay band 2 of 9300 with grade pay of 4800 and the pre-revised scale of which was 7500 to 12,000, which is equivalent to pre-revised scale of 4390 to 11425 per month, which he has been receiving prior to conversion of his service. Since there was no exact pre-revised pay scale in the CCS pay rules 2008 with that of the pre-revised scale of pay of the petitioner, which he was carrying at the time of conversion or absorption, that is rupees 4390 to 11425 per month, his scale of pay was fixed equivalent to the present revised pay scale. That is in pay band of 2 of 9300 to 34800 with grade pay of rupees 4800. The pre-revised of which is equivalent to his earlier pre-revised scale under government of Assam. This is back calculation, Your Lordship. First, my pay was fixed at 9300. What is the equivalent of this in the fifth central pay? It is 7500. Make this equivalent to the fifth Assam pay. This is arbitrariness. On what basis they have done this? And once again, Your Lordship, when I raised this query before the authorities, they gave me a personal pay of rupees 280. If there was no error, why you have given me 280 rupees of personal pay? Page number 70, Your Lordship may kindly take. Page number 70. This was after my representation.
Personal personal pay means what do you mean by personal pay?
There was a difference between the Lordship. I'll read it, Your Lordship. Page number 70.
70.
70, Your Lordship. It is annexure number 12.
Yeah.
Lordship. May I read the order, Your Lordship?
Yeah.
In pursuance of the decision of the meeting held on 2/12/2011, the Director ISST is pleased to grant personal pay of rupees 280 only per month to Dr. Nirav Chandra Adhikari, Technical Officer B, with effect from 9th March 2009 to mitigate the difference arise between pay as per Assam ROP 2008 and pay after conversion to central pay scale as per 6th Central Pay Commission. That means you are considering that there is a difference between the Assam sixth Assam pay and the 6th central pay. To mitigate the difference, 280 was paid. And one more thing, Your Lordship, last one more thing, Lordship may kindly take page. Just a moment, Your Lordship. Lordship may kindly take page number 78.
Yes.
78. Paragraph number 12. Paragraph number 12, page 78.
Yes.
Seventh line from bottom. However, for protection of pay, Lordship has got it.
Yes.
However, for protection of pay and parity of pay of the petitioner, which he would have received after 6th Assam Services ROP Rule 2010 coming into force, his pay has been increased by rupees 280 via office letter so and so, dated 9/12/2011, which I referred to just now, so that his pay is protected. Lordship, next line very important. Be it mentioned here that the payment in which the petitioner's pay was fixed by ISST after conversion is equivalent to the revised scale of pay of the petitioner under 6th Assam Services ROP Rules 2010. This is the specific pleading of the respondent that my pay, as per the 6th central pay that was fixed, is equivalent to 6th Assam pay. That is 12,000 with grade pay of 5400. Now, Your Lordship, my simple grievance is 12,000 with grade pay of 5400 is not equivalent to 9300 with 4800. To bring this on record, Lordship may kindly take page number 166, second last page of the affidavit in reply, rejoinder that I have filed. Page number 166. This page is an extract from the report of the committee constituted to examine the report of the Assam Pay Commission 2008. So this is the extract. I have not bought the entire thing. This is just the extract, Your Lordship. Lordship, at page 165, last line, it says a comparative statement regarding new pay structure. And that new pay structure is given at table 1, page number 166. The Lordship will find here at row number 4. Row number 4, class 1. This is first is as given by Government of India. Payment is 15600 to 39100. Grade pay is 5400 to 7600. The equivalence of this as per the Assam Pay Commission is 12,000 to 40,000 with 5400 to 7600. So my Assam 6th Assam pay of 12,000 to 40,000 5400 can't be 9,300. That was not what the intent of the legislature was. This is the Assam Pay Commission, how they have revised. They have revised taking the base of the central pay. And 12,000 to 5,400 is not equivalent to 9,300 to 4800.
Yes.
So Lordship, what I pray that my pay should be fixed equivalent to this scale, 12,000 to 5,400 as content, as pleaded by the respondents also. They say that my pay is equivalent to the 6th Assam pay, but it is not the case. There has been a violation. My grade pay has been reduced arbitrarily. My pay has been reduced arbitrarily. And all this decision has been taken by an in-house committee. It was not a central government committee or someone from outside who was done this. It was not done by the central government. It was done by the in-house committee of the institute itself, and it was finally approved by the central government, by the DST. Lordship, that's my case, Your Lordship.
My lord, the appellant, the appellant has been working as a Government of Assam employee, my lord, up to 2009. My lord. He was enjoying the pay scale of Government of Assam. At the time when the institute has converted to central government employee, my lord, at that time his pay was fixed under the rule 2008. So, my lord, in 2010 rule, when it has come to effect, he was no longer a Government of Assam employee. Fine. He was already a central government employee. So his salary and pay has been fixed in terms of rule 2008, my lord, CCS rule 2008. So, my lord, the single judge has rightly decided, my lord, because the central government employee, as in when he has converted and his pay was fixed as a central government employee, the rule, CCS rule 2008 has to be applied in case of fixing of the pay. But at that time, my lord, since his pay was not revised, my lord, as in terms of Assam government rule 2010, my lord. So, since the CCS rule 2008 has already come into force, so that is a revised pay. Because at that time, his pay was, prior to 2009, he was pre-revised, my lord. So exact the pay scale, it cannot be equated, it cannot be fixed in the CCS rule. So this equitable, my lord, the formula, that is the pre-revise of which are equivalent to the pre-revise of Assam government, my lord. So in that rule, my lord, we have to see the pre-revised one. So exactly the pre-revise of At 2000, my lord, 4,300 to 11,425. That is the pay scale which was enjoying when he was a Assam government employee. That was taken as a pre-revised. So equivalent to that, my lord, that is 4,300 or 9,300 to 34,800 with a gate pay of 4,800, whose pre-revised was, my lord, 7,500 to 12,000. That is the equivalent. Because at the time we cannot take the pay scale of Assam government pre-revised scale. It cannot be taken as a revised scale of CCS rule 2008. So we have to take the pre-revised one. So that is the exercise we have done, my lord. So we have fixed as a pre-revised, taking into account of the pre-revised of Assam government and pre-revised of the CCS rule 2008. So accordingly, his salary was considerably increased when his pay was fixed in the central government, my lord, employee in 2008 rule, according to him. In the 2009, my lord, at that time, his salary was increased, my lord. Not that his salary was decreased. Only the grade pay, my lord, because as the appellant was claiming for the grade pay, my lord, that is a grade pay of assistant professional in terms of CCS rule 2008, my lord. So his pay was rightly fixed, my lord. That is your submission.
That's all.
My lord, this has been a grievance from the first that 4390 is not equivalent to 7500 as claimed by them. They have arbitrarily fixed my salary and then they have just adjusted it here and there. And to mitigate the difference, they paid 280. Then when I'm raising concern, they are not addressing it.
Order zero.
Obliged.
Okay.